There we go.
Great. So I'm thrilled to have Bret today teaching us about Qtip Trusts. And Bret's background comes from Seattle U, where not only did he get his law degree, but also has a background in psychology, which is interestingly very helpful, because in estate planning, it seems like every single family we deal with has critical interpersonal issues where psychology is important as well. Andy was one of the inaugural people in Seattle U's incubator program. So what he's going to bring to the table for us today is a concept called Qtip Trusts. And what's extremely interesting with that is some tax planning opportunities where you incorporate not only excellent estate planning, but also can get step up in basis on some assets you might not otherwise be entitled to with conventional estate planning. And I think all of us know that the government cannot continually hand out an extra 2 trillion here, 3 trillion there, without creating such a huge deficit that at some point, somehow that's going to have to get paid off. And I think the way that the government raises money, as we know, is through tax policy. And so, that's where I'm thrilled to welcome Bret to talk about this. And what we want to do is employ thoughtful strategies that probably will stand the test of time, and just expect the tax laws to change dramatically over the next few years. So without any further ado, Bret, I'll let you take it away.
Well, great. Thank you so much for having me, Warren and Jeannie. I look forward to doing this. As you've alluded to, I'm going to be talking today about one tool us estate planners are using, in a very specific way we're using them these days, to kind of maximize tax efficiency. And when I mean that, I mean generally. So at the end of the day, if you will, when an estate is settled, that the least amount of taxes are paid, or at least you can take more control over the amount of taxes you want to pay and what types. So first, I want to talk a little bit about just some fundamentals here, things I'm going to be referring to throughout in various scenarios, so you know what I'm talking about with that. So estate taxes, first of all, as you will likely know, are upon the settling of an estate, what can be taxed as it is passed on to the beneficiaries. We have Washington and federal estate taxes. So first I'm going to talk about Washington. Right now our estate tax exemption is $2,193. That means anything below that amount is not subject to Washington's estate tax. Anything above that is taxed on a graduated level. For example, the first million above that is 10%, next million, 14%, and so on. For the purposes of this presentation, however, I'm just going to refer to it as 2 million. I'm going to round to the closest million just to make it a little bit easy, less clunky. Also, that 2,193,000, as you probably guessed, given such an odd number, isn't what it originally was. It adjusts for inflation regularly. So in a year, it may well be 2 million some other odd. So I'm just going to refer to it as 2 million. That's the Washington state estate tax. Now, federally, it's different. Federally, right now, it's 11 million. And there's an added feature with the federal exemption that we do not have in Washington, which is something called portability, which means anybody who does not use their exemption, and I think that'll make more sense when this is all done here, their spouse, their surviving spouse, can use that exemption. So what often you run into here is spouse A dies, leaves everything to the surviving spouse, and that's subject to something called a marital deduction. So, and then the surviving spouse, when they pass, have an exemption of roughly $24 million or $23 million, depending. Now, for the purposes of this presentation, I'm not going to refer to the federal exemption anymore. For the most part, this particular tool we're using comes into play with kind of an increasing trend of clients I've seen that are Washington state sensitive, but not federally, meaning they have in between 2 million and 12 or 24 million. And often they're younger married couples kind of getting started. I'll talk more about them soon. I referred to a marital deduction earlier. And that is both state and federal, where you can leave everything to a spouse and it's automatically not part of your exemption. There's no estate tax on it. And the kind of an exception to this exemption is gifts that are considered terminable. This means that they end at a specific point, as the name implies. A great example of this is a life estate. So if, say, I have my own house that I inherited from my parents, let's say, and on my death, I say I give it to my wife. That house over there goes to my wife. That falls under the marital deduction. We don't need to calculate any estate taxes on it at all. However, if I was to say I give my spouse a life estate in it, and when my spouse passes, then the kids will get it. Now, that is a terminable interest. She can't sell that house other than her life estate, and it's not hers to pass on upon her passing. That would not qualify. So that would therefore have to come out of the exemption or be taxed, depending, whatever that life estate is calculated to be worth. So it's most terminable interest. We'll talk about exceptions soon too. And as Warren talked about earlier, the step up in basis is another big topic with this particular tool. So an asset gets a basis when it's purchased or is acquired one way or another. And then for the most part, capital gains are paid on any appreciation when an asset is sold. So an example I'm going to use that's really nice, easy, round numbers, and not completely unusual for our area here is, let's say a house was purchased for $500,000 a decade ago. Not unlikely that it'd be worth about $1 million now. So you buy that house in your lifetime, you sell it in your lifetime, you're going to have that $500,000 to pay capital gains on. However, if you leave it, or if it is left by virtue of an estate, somebody passing, it gets a step up in basis. So whereas I bought it here, sold it here, you're paying for this amount. Now imagine that I leave it in my will to my children. They receive it at the basis, at the fair market value of it upon my death. So if I give it to them as a gift the day before I die and they sell it, they'll pay a lot of taxes. If I give it to them through my will and then they sell it, they won't. So that is a step up in basis. Generally speaking, for the purposes of this, a step up in basis is a good thing. Okay, so that's kind of the fundamentals. We're going to talk about Qtip trusts now. And what Qtip stands for is Qualified Terminable Interest Property. So this is a specific classification for property, and it's made via an affirmative election for the property. You can't have it kind of passively happen. It can happen in life. It can happen after death, which is most common, especially the scenarios we'll be working with today. And it is a terminable interest, but as the name implies, it qualifies for that marital deduction. They are highly flexible, but there are certain rules. So I'll back up here a little bit. They do function like a trust. You know, example, I leave 100% of my property in a Qtip trust. They make a federal election for Qtip property for, let's say again, all my estate. It functions like a trust. It's for the benefit of my spouse and my irrevocable trust. I say I leave everything, you know, in this trust for the benefit of my spouse during her life, and when she passes, everything goes to my kids. So that's an ordinary trust. Now, for it to be a Qtip, there are certain rules. And we'll get into why we want to follow these rules and why we want it to qualify as a Qtip. The income must be distributed to the spouse at least annually. It can't just accrue in there. But it can also be set up to allow the spouse to take either the greater of 5% or $5,000. And by 5%, I mean 5% of whatever is in that percentage of property for which this election has been made. This is kind of maybe an old school use for it, but it was traditionally used, kind of came into popularity to ensure that a present spouse that you want to provide for doesn't disinherit children from a previous spouse. So like I said, I leave this all to, let's say I have children from a previous relationship. I know that, you know, if I die, I want my spouse to be taken care of. But I also know there's nothing to prevent her from going off and remarrying or having other children or whatever the case. And I want to make sure that my property goes to those beneficiaries I originally designated. We're not going to talk too much about this today. I don't actually see this coming up as much in clients saying, I want to make sure this happens. Certainly does. It's totally reasonable use of one of these. But this is kind of how it started, and then people started to tweak ways to use it. We'll get into that a bit. It's also very useful because it provides creditor protection. So if I know that there could be some serious debt issues down the line, I leave everything to my spouse, creditors can come after that. If I leave everything in a Qtip trust for the benefit of my spouse, they can't get at it. It's not hers in that sense for them to access. That can be useful. Now, interestingly, I talked a bit about, we have Washington estate taxes, we have federal estate taxes, we have marital deductions in both. Similarly, a Qtip election can be made for both Washington or federal purposes for specific property. So I'm going to talk about how we kind of calculate a Washington taxable estate in a nutshell. And I should say, too, that for just about everything I'm saying here, there will be the odd chances there is some exception, some tweak to it that would make it work differently. This really is kind of a 10,000-foot view to give you an idea of how we estate planners are approaching things when you come to talk to us and you want to talk about tax efficiency. This is one of many things. So to calculate a Washington taxable estate, you subtract that exemption of $2 million. So you have a certain amount, take $2 million off. If that's all of it, then you don't have to worry about estate taxes anymore. If you got anything above that, we'll see if there's any other exemptions that apply. The marital deduction, you subtract that from allowable assets. And then there are a host of other kind of technical deductions. For example, portions of family-owned businesses, if they fit with Washington state law in a particular way, you can have certain deductions based on those. Feel free to contact me if you'd like to know more about that. I think that certainly can apply in lots of situations. But for the purposes of this presentation today, I just want you to know that there are other ones out there, but we're not really going to get into the meat of those. This is what we're going to be talking about. This interesting bit of work that was done relatively recently, where it says also it's calculated by, you subtract the property transferred by a predeceased spouse for which a federal Qtip election was made, but only if that spouse also made a Washington Qtip election. So a little bit abstract and clunky right now. Let's try to bring it down to earth with some hypotheticals. As I mentioned earlier, I'm seeing a lot of families get kind of started. They're reaching that point in their lives where they have kids, their estates together, maybe tax sensitive, so they're thinking about that. So more than $2 million combined. I'm going to talk about this couple as Alex, Chris, and the kids. I'll be referring to them kind of throughout this. Usually, often they can, and like I said, there's exceptions on all sides of this, but here, for the purpose of this, Alex and Chris have about $4 million. It's almost exclusively community property. They have very little personal property. Now, specific to our area here, not just our area, but a lot of West Coast, but Seattle, Pacific Northwest, a large portion of a lot of people's estates are in real estate. And this is because real estate could have been purchased before one of the spikes, roughly a decade or so, 15 or 20 if they're really lucky. And so it has appreciated a lot. People bought little houses in quiet little Seattle, and things aren't quite the same way anymore. So estates have changed considerably as a result of that. So this is kind of the estate I'm looking at, and that's what this applies to quite a bit. So let's say Alex, Chris, and the kids, with their $4 million combined, their $1 million house that they bought for $500,000, don't really do any estate planning, or they just have a simple will. What I mean by a simple will is kind of the bare bones that I see the most of, which is I leave everything to my spouse if my spouse survives me. If my spouse does not survive me, I leave everything to my kids. Both spouses have this arrangement with the other in relation to the other. Let's see what would happen in this case. Upon the death of the first spouse, there's no taxes due because A, half of the community property, which is $4 million, is $2 million, is below the exemption, or is the exemption for the purposes of this. But also there's that marital deduction. So I leave everything to my spouse. My spouse gets everything, no estate taxes for a couple of reasons. And because it's based on my passing, there's a step up in basis in my portion of the community property. So my half of that $1 million house now gets a step up, which is, getting a little clunky when we have half a house with a different basis than another, but we'll leave those calculations alone for now. So this is going to be referred to as the deceased spouse, the first to die. So then, say the second spouse lives a bit longer, second spouse passes away. The second spouse has, let's say, just for the purpose of this, roughly 4 million. Still, there hasn't been a lot of growth in the estate since the death of the first spouse. The estate taxes will be paid on anything over that 2 million. We take that one personal 2 million exemption out of there because there's no portability. They can't use the first spouses. And, however, there will be a step up in basis for all assets. So now, this is the surviving spouse, the second to die. Let's see what this would look like. Kind of in a easiest graphic on earth. The first red estate of the deceased spouse passes to the blue surviving spouse. Nothing is paid because the exemption or marital deduction. There's a step up in basis then. When that spouse dies, there's another step up in basis, and any amount exceeding that exemption is taxed. So how would you calculate this on the fly? In a quick nutshell, obviously it's never going to be quite this straightforward, but let's deal with it in bite-sized pieces here. Upon the death of the surviving spouse, the Washington estate is calculated $4 million, right? That's what we're starting with. Subtract that exemption of the per person surviving spouse's exemption. So now you've got 2 million. So you're going to have this taxed presently 2 million over the exemption. The taxes due on that would come to about $240,000. But you'd get a full step up in all assets upon the death. So let's say Alex, Chris, and the kids have friends who, you know, set up their wills long before contemplating this type of estate where they'd have to worry about estate taxes. And they're saying, you know what, we're heading towards the same position here. We'd rather our kids decide what happened to that $240,000, or at least minimize that as much as we can. And they hear about this other kind of old, been used for a while, still used presently. By old, I don't mean outdated. I still do these a bit. Technique called a bypass trust, where you basically bypass the estate of the surviving spouse. So, upon the death of the deceased spouse, the exemption amount is put into an irrevocable trust outside of the estate of the surviving spouse. Again, in this case, the first to die has half of the community property of 4 million. So 2 million, that's the exemption amount. You put that in this other trust rather than giving it to your spouse. Now, this trust is for the benefit of the spouse. The income generated by it goes to the spouse. And remember, that spouse still has 2 million too. So you're not depriving a spouse of everything. They still have their own community property or anything that you didn't put in this trust. Now, the principle of that trust, however, this is where the rules come in to maintain the benefit we want from this, can only go to the spouse according to what is considered an ascertainable standard. I use the acronym HEMS for this. You might hear MESH, same 4 letters. It stands for Health, Education, Maintenance, and Support. If there's ever any IRS scrutiny, they're going to make sure that this bypass trust was used according to this ascertainable standard. They see, huge amounts going to the surviving spouse for no clear reason, for whatever, travel, this, that, or the other thing that couldn't arguably fall within this ascertainable standard. The purpose of this trust is going to be largely defeated. So let's look at some of the purposes here. When the surviving spouse passes away, now mind you, there's the trust here with roughly 2 million, depending what's happened since the death of the first spouse. And we've got the surviving spouse's amount of 2 million. They're separate if we've done things right. They both pass to the children. The trust passes outside of the surviving spouse's estate. However, there is no step up in basis at this point. There is only a step up in basis upon the death of the first spouse. So depending how much time has passed, if there's been any property in there that has seen any considerable appreciation, we're not able to capture that benefit of the step up in basis. However, it passes as a trust, it's not an estate, passes to children with no estate tax. Similarly, the 2 million in the surviving spouse's estate passes with the exemption. So nothing is paid on that. And that gets the step up in basis. So half of the money, or half of the assets, I should say, flowing to the kids, gets a step up in basis. That's the stuff in the surviving spouse's estate. Same clunky graphic here, you get the idea. Red gives everything to the bypass trust rather than the spouse outright. It is left to the trust within the exemption. If it was more, if you put 3 million into the trust, anything above that 2 million would have been taxed at that point. But here it's 2 million. There's a step up at that point. Marital deduction doesn't come into play, but it doesn't matter because we're in the exemption. The bypass trust kind of feeds income to the spouse during the spouse's life. Also, the principal according to that standard. And then upon the blue surviving spouse's death, everything goes to the yellow beneficiaries. Half coming from the spouse gets a step up. Half coming from the bypass trust does not. No taxes paid. as I just explained. There we go. Let me know if I'm going too fast at all. I realize I'm saying everything that's on the next slide here. So the result, surprise, no estate taxes. However, we missed that big step up in basis. So now let's say Alex and Chris, they've seen friends to which this has happened, and they say, you know what, there's a solid decade between the death of other people we knew, or friends' parents, whatever the case may be. And the children received an asset that was subject to considerable capital gains. Is there any way we can avoid that? We want to get a step up in basis on everything that we can. Heard about this odd tool some people are using called a Qtip basis. They come and they talk to me, we figure out what we can do. Oh, everything I just talked about, all right. The Qtip election. So with this, upon the death of the first to die, the deceased spouse, instead of placing things in a bypass trust, or instead of giving it to the spouse outright, it's placed in a Qtip trust for the benefit of the spouse. Now, this provides income to the surviving spouse, paid at least annually for it to be a qualified terminable interest. You get that creditor protection we talked about, which is advantageous in many cases. And they get some question-free access to principal. Here, because the first to die leaves $2 million in the Qtip trust, the surviving spouse gets $5,000 or 5%, whichever is greater. So here, that's $100,000 a year, kind of allowance from the Qtip trust that can be spent on whatever they want. But we've made some issues here. So upon the death of the surviving spouse, all the property passes to the children as the surviving spouse's estate. It doesn't work like the bypass trust. So the benefit is that you get the step up for all assets. So you can see here, same thing. Red goes to the blue Qtip trust, and the Qtip trust and the spouse are both blue because the estate is treated the same, even though they operate, the assets in the spouse's estate and the Qtip trust operate a little differently. However, when that surviving spouse passes away, there's a full step up in basis and everything, but probably seen the issue we've created. Let's calculate this particular estate plan's tax. Since both the Qtip election assets and the surviving spouse's personal assets equal $4 million in this case, again, you subtract that one single person's exemption, which is $2 million, and the result, we're back where we started. We have the $240,000 roughly on that estate. Yeah, we got the full step up in basis for all assets. We had the protection, the first to die could rest assured knowing everything was going to where that spouse wanted it to go upon their death. It was all protected from anything there. But again, we haven't defeated this estate tax issue. So, gets us to what we're talking about today, this relatively clever way people in Washington now are using this bit of the code that may not have been created for this purpose, but works this way. At least it hasn't been challenged yet. Let's see how we can do this. So upon the death of the deceased spouse, they make a federal Qtip election for 100% of their assets, so $2 million. And they make a Qtip election for 1% of their assets, that's $20,000. Now, it looks weird saying 101. It looks like it should be 99% and 1%. It's not an error. You can have assets be in either one or both. So you can do this. So it looks like this. We've seen this before. I know I've showed you a lot of these, but it's a little bit different in that the trust on the left there, you can see there's $2 million, which there's a federal Qtip election, and only 1% of a Washington Qtip, that's the 20,000. Everything goes the same upon the death of the surviving spouse, full step up in basis in all assets, both in the spouse's estate and in the dual Qtip trust, we'll call it. So the future beneficiaries get all that with the step up. But now let's go look at how that tax is calculated. I'm going to go back to a slide I did earlier. Here, I'm going to remind us how this goes here. We take the $2 million out of the full $4 million. We subtract a marital deduction. In this case, there is none. This person deceased after their spouse. They didn't remarry, so there's nothing to leave under a marital deduction. We're not worried about family-owned businesses in this case, anything like that. But we do have this odd bit that I keep talking about. You subtract the property transferred by the pre-deceased spouse for which a federal Qtip election was made, but only if that spouse also made a Washington Qtip election. So this is what that estate is going to look like. Upon the death of the surviving spouse, the estate is calculated as follows. You start with that 4 million, right? Just like we always do. You subtract the exemption, that leaves 2 million. Then you subtract the federal Qtip election, which was made for 2 million, leaving $0. And then what you need to add in there is the Washington Qtip election, which leaves $20,000 as the taxable estate. The result, the estate tax on $20,000, which is now 10% for the first million over the exemption, $2,000 paid. And before I go on, I'm going to say the obvious question here is, why didn't we leave 0.5%? Why don't we leave 1/4%? How about 0%? Could we do that? Would that technically work? This is asked. The conventional wisdom right now is 1% is probably the optimum amount to avoid any type of scrutiny or getting challenged with. And this hasn't happened as far as I'm aware yet. Washington challenging this type of plan. And this is to keep it kind of safe. It makes it a clear, distinct, whole number. It kind of defeats, hopefully, arguments from the state that this is illusory and we should be counting it all in there. So now we've paid $2,000 in estate tax to Washington, and you get a full step up in basis in all assets. This is pretty optimal. So I'm going to consider that a success. And so, like I said, one of many options being used here. I like this one. I think it's particularly clever. It leaves a lot of room to move. You still get all that Qtip flexibility you don't get with the bypass trust. You get the full step up that you don't with the bypass trust. And it's just kind of a neat way of using the code, I think, to get maximum efficiency. So if anybody has any questions at all, I'd be happy to try to answer them at this point. If you think of anything later, feel free to contact me. I'm happy to chat about this stuff. We can figure something out. If none of this applies to you, feel free to contact me and see if anything else in my tool bag here might make more sense for your particular situation. There's, infinite possibilities out there for infinite estates. So hopefully we can make something work. Thank you very much.
That was a great presentation. So we'll see.
Thanks, Mark.
Does anybody have any questions? I know this was a lot of material to go through very, very quickly, but I think the goal that we're going to have for you is to bring you creative strategies. And so this is the first of many that Bret and I will be doing. And it's just a great way kind of to launch. And so we'll open it up. Does anybody have any questions?
Yeah, how do you, so I guess I'm still in a place in my life where stuff's getting moved around from, different investments. How do you capture that in all this? Like, how do you
Great question.
capture
All right.
different monies that are being moved and placed in different locations?
That's one of the things that's so incredible about not just the way that Qtips can be set up, but the way Washington laws can work. There is what's called TEDRA, which stands for Trusts and Estates Dispute Resolution Act. So I'm going to kind of come at your question from the back, and then I'll get to the easy part here. At the end of the day, if you'll excuse the expression, if all interested beneficiaries come together, they can do quite a bit, so long as it doesn't defeat the intent of the testator. So if you don't, let's say somebody passes away. This is actually an interesting idea that has come up with where someone has passed away, for example, before this Washington election was made possible. I'm pretty sure courts have allowed, and they've gone back and forth on whether or not they can, after the fact, change this. Now with TEDRA, if all interested parties come together, usually they are able to modify an estate plan, again, so long as it doesn't defeat the main purpose, and say, okay, so the person who left everything here made clear they want it all to come to us. They made clear they want maximum tax efficiency, but at the time they were unaware of, or whatever the case is, of, let's say, the optimum way to do this. They can come together and change it with or without judicial intervention, depending on the specifics, and tweak it to help. So, if you're in a position now and you don't know where you'll be then, often it can be formed around that. But with Qtips, you can have a relatively flexible, you usually put it in a trust. So it's kind of a testamentary trust. Or I'm sorry, you put it in a will. So you say, I want my beneficiaries to be able to create a Qtip trust if it maximizes tax efficiency upon my passing. So at that point, it doesn't matter where certain assets are, in what vehicle they are, the determination can be made after death the probate attorney, whoever's handling it, the personal representative of the estate can sit down and say, okay, where are we right now? How can we make this work in the most flexible and efficient way? And even in ways that maybe you didn't contemplate in your lifetime can be used at that point. So I rarely in estates will, unless it's very specific bequests, for example, list where every single thing is in the will. Now you want to have a list, obviously, and update it as much as possible for the sake of the personal representative to be able to access things. But to say, I want this particular investment account to be treated thusly doesn't make a lot of sense because they change all the time. The same way, I right now wouldn't leave my house, or I'm sorry, my car, let's say, I wouldn't say I leave my particular car to particular beneficiary because, know for sure, of course, but odds are I'm going to have several cars before such a clause would even be relevant. Rather, I leave all of my property to whomever. Does that make sense?
Yeah, no, that was good. Thanks.
Sure. Answer any other questions for anybody?
I have a question. Can you hear me?
Yes.
What if you have estate tax obligations in other states besides Washington? Does the same strategy work?
That is a great question, and I'm afraid not one I am either equipped or allowed really to respond to. As a Washington attorney, I can't really give advice out of my jurisdiction. That's kind of me hiding also behind saying I really couldn't say. Different states do things so differently. If you have the way that different estates interact, or I should say an estate with property subject to different jurisdictions' estate tax laws, that's certainly something you're going to want to harmonize as best as possible. As kind of an aside, I'll say this, some of the biggest problems I run into deal with that. People who have real estate in various jurisdictions in their personal names is one of the biggest messes I run into more regularly, including oil, mineral lease rights that you can be all over the place, including in other countries. Timeshares are considered usually a real property interest. And if these aren't put in a trust or dealt with somehow before the owner's passing, a separate probate, an ancillary probate, needs to be done for each and every one of them, and it can become absurdly expensive. I've dealt with that a lot. I could do another presentation about that.
That's okay.
Good question.
And I think what you were saying before, were you saying, because I don't think that I heard this right, that if they do not have a provision for a Q-tip, that if the heirs got together, they could say post-death that they want to create a Q-tip, and that
I've heard of it happening.
That's
because if at the right, and you're going to want to have something in the will to make relatively clear. And I'll say this, I haven't dealt with that personally. I have not put that together. I've luckily not had to put that together, but you can do a lot with TEDRA as long as you get everybody on the same page.
Yes, I think that's great. But I think what I also advocate, as do you, is to do good and thoughtful planning up front.
Absolutely. That's always easier, always less expensive, always less burdensome for beneficiaries who are often dealing with a lot at that point emotionally and don't want to have to go through such things.
And what I laugh at with TEDRA, and think of the estates that I'm dealing with now, is getting the heirs to agree on anything. Yeah, is somewhat challenging.
I think that's kind of a trick. That's kind of the monkey's paw in TEDRA. It seems like such an easy thing, and then you run into that. You got to get everybody, figuratively or literally, in the same room together and agree on. And so if you have any kind of specific bequests, that can make it virtually impossible.
Exactly.
Yeah.
Well, thank you very, very much. That was an excellent.
Oh, my pleasure. I like this stuff.
And we will send out information. If anybody's got questions, feel free to contact us or Bret. And I wish you all a very, very safe and beautiful week.
Thank you so much. You as well, Warren. Thanks so much for coming, everybody. Like I said,
Thank you,
let
Warren.
me know if you have any questions. I'm here for you.
Thank you all.
All right. Bye.
Bye.
Bye.